It's a striving trend that we are noticing, the growing trend of judicial impunity that we're seeing in this country. And I want to say, despite the naysayers, is that unless there's a government policy saying that all professionals should not be given work, there should be no discrimination. We have architects, we have doctors, we have engineers who are all hired by government, and at the same time external professionals are still taken to do the work. World over, we have seen professionals working hand in hand with the government and government agencies, particularly because of the arena of expertise and capacity. And therefore, to single out the entire legal profession of the entire country is not only absurd, illegal, and unconstitutional. In the recent past, several attempts have been made to stifle the legal practice space in what we are apprehensively signifying a nefarious scheme to deprive the legal profession of a fair opportunity to work and earn competitively. The petition and ex parte orders granted by the High Court sitting at Nakuru petition E001 of 2026, are a culmination of a protracted cyclic attempt to cut off private practitioners from the public sector economic ecosystem. First, on 8th July 2020, the then Attorney General circulated a resolution of the National Development Implementation and Communication Cabinet Committee directing that all state departments required written approval from the Attorney General prior to contracting external legal counsel, and that all engagements with external advocates otherwise issued without occurrence from the Attorney General prior to the said resolutions be terminated. The Law Society of Kenya filed an application for judicial review seeking to quash the impurged cabinet resolution on account of its manifest irrationality and illegality. In a judgment dated 7th July 2023, the High Court, the Honorable Mr. Justice Jairus Nga, allowed the application and quashed that impurged resolution. In his reasoning, the learned judge opined as follows: the procurement of goods and services is such a crucial task that Article 227, Sub-Article 1 of the Constitution is categorical that it is an exercise that must be fair, equitable, transparent, competitive, and cost-effective. Certainly, the values of fairness, equity, transparency, competitiveness, and cost-effectiveness are unlikely to be achieved in procurement of goods and services for the government agencies and public authorities if such a task was left to the whim of an individual. Notwithstanding the clear rationale of the High Court on the matter of contracting of external counsel, a further onslaught was waged against this otherwise lawful and standard practice in 2024. In that instance, the fourth petitioner in this petition before the High Court at Nakuru lodged a petition before the National Senate seeking to restrain county governments from hiring law firms to represent them in civil cases. In its March 2025 report on the petition, a joint committee of the Senate Standing Committee on Devolution and Intergovernmental Relations and Standing Committee on Justice, Legal Affairs and Human Rights noted that restraining county governments fully from outsourcing legal services threatened to violate the provisions of the Constitution of Kenya 2010, the Public Procurement and Asset Disposal Act, and other relevant statutes. It's clear to say without a doubt that this is forum shopping because he failed in one instance and has looked to beguile the judge instead of presenting all information before the court to seek orders that look final at the interim stage. For the avoidance of doubt, the other relevant statutes referred by the Senate include the Office of the Attorney General Act, the Office of the County Attorney Act, both which provide for the retention of external counsel as may be necessary at sections 25 subsection 2 and 22 subsection 2 respectively. This does not allow room for public entities to utilize This not only allows room for public entities to utilize specialized service of private practitioners, but also address the fundamental concern of the capacity of the Attorney General and County Attorney's offices to handle the volume of work they have. Nevertheless, and despite the resounding and logical stamp of approval on the use of external counsel, 7 petitioners have now moved to the High Court of Nakuru in the hope to hammer a final nail into the coffin of the public sector as an avenue for legal practice. In the petition, the petitioners raise issues of the existence of a fully employed state and county council, high legal fees, and the need for fiscal responsibility as ground to deny private practicing advocates a role in nation building for fair gain. From the onset, we note that beyond their evident lack of novelty and ingenuity, these grounds are symbolic of a tired rhetoric against a profession that unreservedly dedicates itself to upholding constitutional values and protecting public interest. We register our concern over this outright misunderstanding and mischaracterization of the work advocates undertake in the favor of public entities. For the avoidance of doubt, the retention of external legal counsel follows a strict, rigorous, and competitive procurement process in accordance with the Public Procurement and Asset Disposal Act. All law firms that represent and act on behalf of public entities are required to demonstrate a set standard of competency, capacity, and experience before taking conduct of matters of public importance. These qualities speak to the necessity and reasonableness of engagement of private practitioners to handle matters on behalf of public entities, which is common practice world over and is not peculiar to Kenya. Ultimately, the engagement of external counsel fills otherwise unsurmountable gaps in effective functioning of public entities. Private practitioners handle matters from which conflict of interest may arise in the part of government-employed advocates, offer independent expertise on governance structures and issues, when their conflict of interest issues mitigate workload excesses which would create backlogs and non-compliance, and ensure that the state remains compliant and strict constitutional and procedural timelines without the risk of abandoning service delivery to the members of the public.
Further, legal fees payable to advocates are neither illusory nor legally indeterminate. Calculation of legal fees is a statutory regulated mathematical process that is both traceable in law and subject to good faith negotiations with and assessment by the relevant public entities. In any event where fees are indeterminate or no consensus is arrived upon, the same are subject to taxation by the courts, a process well anchored in law. It is therefore untenable to suspend legal services altogether in the name of capping expenditure on legal fees, as the law provides adequate avenues through which fees can be regularized. Against this backdrop, the Law Society of Kenya notes that the instant matter is, in the grand scheme of things, nothing short of a direct affront to the livelihoods of our members. We strongly oppose this ill-advised move and urge those involved to reconsider this overzealous upheaval of legal practice. The right to representation of one's choice is a fundamental right enshrined under Article 50 of the Kenya Constitution and is at the core of the fundamental principles of social justice, access to justice, the rule of law, and human rights. This crucial constitutional right carries with it the right of lawyers to appear before courts on behalf of their clients, which right is specifically recognized under Article 19 of the United Nations Basic Principles on the Role of Lawyers, 1990, which bars courts from refusing to recognize that particular right. Accordingly, we are minded that the ex parte conservatory orders granted by the court are inconsistent with the Constitution, violate international norms, and ignore attendant public interest arising from access to adequate, quality, and effective professional services by public entities. While the court has the discretion to grant such conservatory orders at an ex parte stage, as it deems fit, the exercise of that discretion must adhere to the principles of public interest, constitutional order, and institutional integrity propounded by the Supreme Court in Gitarau Peter Munya versus Dixon Mwenda Kithinji and 2 others, 2014 EKLR. The blanket orders issued by the court fail to appreciate the adverse effects it poses on parties that are either not before the court or before it and have not yet been heard. The retroactive effect of the order poses significant prejudice to several law firms which have put in their time and craft in delivering professional services to public entities. It proposes to suspend payment of lawful dues owed to legal practitioners even after they have rightfully assessed cost by courts of competent jurisdiction. This is in no uncertain terms an absurdity of the highest degree. In their totality, these orders are indicative of a sharp deviation from the binding principles applicable to discharge of judicial authority and constitute a blatant act of judicial overreach, consistent with the rising trend of impunity within the judiciary. We are increasingly concerned by the impunity guised as exercise of judicial independence that has characterized the judiciary in the recent months. Just in November, Honorable Mr. Justice Bahati Mwamuye inexplicably lifted his earlier orders that had halted the nationwide recruitment of police, effectively returning the status to the status ante and allowing a process whose legality remained in question to proceed. Not long after that, a 3-judge bench of the High Court comprising of Honorable Justices Aburili Chigiti and Muteti in High Court Constitutional and Human Rights Petition E110 of 2025, Kennedy Echesa Walubengo versus State and another, delivered another bombshell illustration of judicial impunity in the now infamous judgment suspending the Judicial Service Commission's discharge of its constitutional function under the pretext of a lack of codified procedures or regulations. We are apprehensive that the current pattern of abuse of judicial powers threatens to spark outrage amongst both the members of the public and the members of the Law Society of Kenya. It should not be lost on the judiciary and the members of the bench that while the Constitution affords them a degree of independence and immunity, it does not grant them the privilege of invisibility or unbound reverence. We shall not sit back and watch the judiciary, the last line of defense for the people of Kenya, run rogue against its own people. Unless this trend is nipped in the bud and with the requisite firmness it deserves, we are prepared to agitate for a radical surgery as a means to uphold and protect our Constitution. As things stand, the Law Society of Kenya is collating all emerging instances of ineptitude, judicial arrogance and abrogation of duty on the part of judges and judicial officers. We will be taking necessary action against all breaches of duty and intend to end this cycle of abuse of judicial authority. In the interim, the Law Society of Kenya has instructed an advocate to act in its behalf in Nakuru Petition E001 of 2026. We have since filed an application seeking to review and set aside the ex parte conservatory orders issued by the Honorable Mr. Justice Mohochi Mukira and are hopeful that this regrettable omission in law will be rectified swiftly. While we purpose to continue discharging our duties to members of the public diligently, we retain equal commitment to protecting the legal practice environment and ensuring the livelihoods and well-being of our members is not interfered with, undermined, or interrupted. Thank you.
And maybe as we close, we just want to add that the reality is, if you're saying there's corruption, we have the ESCC that can investigate corruption. We have the Advocates Complaints Commission. We have the Law Society Disciplinary Committee for rogue lawyers. In any profession, there are rogue lawyers, and however, there are provisions under the law that enable you to be able to investigate, report, But situations where we have individuals going to court masquerading because one misadventure has failed, to seek for another opportunity to eat their cake, using the law and abrogating the full process of the law. There are procurement processes and there are provisions under the law in how you can challenge procurement processes. But to purport that it's a public interest litigation matter, to halt payment of even work that people have already done. Some even are holding judgments, having challenged decisions of public entities and gotten judgments of the court. And one blanket order purports to nullify judgments that have been issued even by the very court, and some even higher than that court. We need to have a system where judges exercise their discretion, taking in consideration the Constitution and the law that is provided there under. That we do not have such archaic and sweeping orders affecting an entire legal profession without even having had the very participants and individuals who are not even participants of those contracts purporting to get sweeping orders that are almost at finality stages at ex parte level. Thank you. If you have any questions, we may take them now.
I hope you note that we have highlighted that this matter had already been litigated before, and so we see an abuse of a court process where petitioners are going to court without explaining to the court that the matter has already been settled. And they are busybodies, in fact. If we must state the factual truth about professional services, advocates or lawyers that are at the bottom feed of professionals who offer services to public bodies. The greatest professionals that benefit highly from services, and these are professional services, they are not illegal services, are engineers and doctors. Take an example. When doctors go on strike in a public body like the Nairobi County office, services do not stop at these medical facilities. They input and inject private doctors who undertake locum. Why discriminate on one profession, on one body of profession? That is the question that we are asking. It is completely preposterous. It is unconstitutional and illegal. You should be posing those questions to these petitioners. And in fact, you should be asking these petitioners why they are not highlighting that their issues have already been resolved in court as well as in the Senate.
Question. I'm Chris Owino from Ramogi TV. One of the petitioners actually cited the prudent use of public resources in hindsight of a damning revelation by the control of budgets that said Nairobi County used 21 billion to hire private legal practitioners just to handle its cases. Don't you think that some counties have taken advantage? They've got county attorneys and they've got solicitors, but they go extra mile and use the private law firm instead of using the county attorneys. Don't you think they're slipping on the job?
Well,
perhaps, yeah.
Well, you need to look at the magnitude of the number of cases. If you just count Nairobi County, vis-a-vis the number of cases, almost in every land dispute, in every dispute that arises in Nairobi County is a party, vis-a-vis the paltry number of advocates they have. So it means you're rendering the county immobile, because you will not be able to have defense in those matters. Even the Attorney General's office, if you look at the number of almost all matters, they attach the office of the Attorney General, and look vis-a-vis the paltry number that she has of all cases around the country, she will not be able, or rather the office of the Attorney General will not be able to handle those matters. So in essence, we will go back to a situation that we had in our country. A lot of matters, judgment is entered because there was no representation. It's impracticable to provide that all those bodies represent themselves vis-a-vis the number of advocates that they actually hire. Now, secondly, if it's a question of prudent use of funds, we have public procurements. There is assessment of fees before they are paid. The question is there implementation and enforcement? And so the question is, even the recommendations that arose from Parliament, from Senate and the Justice Affairs Committee was that implementation to be done and better structures to monitor and evaluate before those payments are done. So instead of coming up with a proposal and even asking the court that this is something that has been done, or there are these proposals that have been set in place, what they're actually trying to do is ensure that there is a total halt of provision of services. Look at, I've seen some of the bodies even put IEBC. If you say vis-a-vis the election period, over 400, over 200 cases vis-a-vis 5 to 10 lawyers that are employed, that they represent with timelines of 6 months for hearing and determination. Those are impossibilities. And noting that some of these petitioners are perennial people who file cases before the court, you'd imagine then the aim is to ensure that they get judgments entered without representation, because it would be impossible for the government bodies to be able to have representation in all those matters. There are systems under the law. Challenge it under procurement, challenge under anti-corruption, that if this is corruption cases, if it's money laundering, we have the Financial Reporting Corporation that can investigate those issues. So there are government bodies that have been set in place to be able to investigate any rogue elements. And let us be reminded that it's not just the lawyers. We have been seeing the Office of the Auditor General raising hue and cry about different government departments. We see catering in billions. Why can't we ensure that the caterers that are employed do the catering, so that we don't have billions lost into catering? We see furniture being done in billions. Why can't we have those processes change, that those who are actually hired do the work? We see the contractors, they're hired, they're engineers in government. Why can't they do the work? We have seen the kind of shoddy work. We're losing not only money, but also losing lives. And so let us not be discriminatory. Let us look at it as a holistic issue. So that if government is employing adequate, we say these have been set in place. But getting such sweeping orders without having set any measures in place, it not only leaves us or the country to a lot of judgments entered, because at the end of the day, when they lose those cases, money will have to be paid. And that money is not going to belong to the government. It's going to belong to the taxpayers, are the ones who are going to pay that money when they are sued and they lose those cases. So in the end of the day, we must look at it as a holistic issue, as a holistic question. So that if it's a government policy for all professionals, then all professions, they either hire or they don't take. So there is clear and a fair process that is done. It is not an issue of just one profession that is being singled out. Yet even the major issues of concern that the Auditor General has been raising, where billions and billions are being lost, is not addressed. But the legal profession seems like the easy target to be the one, because that will affecting the independence of the bar.